pick up 2 points outstanding. First one is a smaller one. My Lord Justice Holgate's question about, this is the end of page 305 of the core bundle, end of the WMS.
The criteria.
Relevant criteria for intervention powers. The answer to that is the criteria are published. They were consulted on for the first time in 2016, and I understand before 2017, when they were published, there were no such criteria. They were published in the Housing White Paper 2017, and then that was reflected in a Written Ministerial Statement. So that's there in 2024, so after the WMS in this case, they've been updated now, so they're now actually in PPG. They are in, yes, we'll send copies of both the 2017.
The one in force at the time. Yeah, just to get a feel for it.
Does the court want to see the current ones, which would apply, I suppose, to the policy? We'll send copies.
I think
both. They're in fairly general terms, unsurprisingly broad and general, I think would be my point about them. The second question is my Lord Justice Lewis's question about local energy efficiency standards. That's on the previous page. And reflecting on that and how that fits with the Planning and Multi-Purpose Act, how that fits with the Planning and Energy Act, Section 1, I think the correct answer is not that it goes further, it's entirely within, but it's perhaps what one finds there is a facility within this policy for planning authorities to set local energy efficiency standards, whatever they might be, provided they meet those criteria. So it provides an opening, and if one then looks at the statutory language, it's page 27, it says section 1(2)(b). That's a setting out of standards.
Sorry, you said section
1(2)(b). It's a setting out of standards in very broad terms within the WMS. Local energy efficiency standards that are higher. It says you can do those, provided you meet those criteria.
And when you say criteria, what are you referring to again?
That's going back to the WMS. It's the rationale, I think you call it, rather than criteria.
I'm really sorry, I'm just not with you. Are you looking at a word on the page, criteria, or?
No, it's the word is rationale. It's on page 304. It's the bottom of the. It's just was what one has there, and to read it all together. The sentence about which I'm asked is planning policies that propose local energy efficiency standards for buildings going beyond should be rejected. So don't like those if they do not have. So then there's what I'm calling criteria. It's that rationale, and it's those 2 bullet points.
Right. So, but sorry, what are you saying? What are you saying about the 2 bullet points?
Well, they are qualifying what the local energy efficiency standards are that are endorsed. Take that language from section 1(2)(b) by this Written Ministerial Statement.
So, okay. So you're saying that what a local authority wants to put forward in its local plan is a local energy efficiency standard, going beyond, for example, draft FHS.
Yeah.
When we go back to the statute, is to be treated as an energy efficiency standard endorsed in a national policy or guidance.
Yeah.
But it's a standard which is not expressed at all in that guidance.
It's left open in the guidance, subject only to those criteria. So the guidance gives some facility.
Right. So if I've understood you correctly, then this document is one something that provides national guidance. Say you, the local authority, can put in the draft standards in the draft FHS in your policies. Secondly, this document is also an exercise of endorsing policies under 2B, and you're saying if a policy fits within the 2 bullet points, that is itself something that is an energy standard meeting the definition set out in 1(2)(b). Is that it?
Yes.
That's, gosh.
That's it, and I think that's the right way to reconcile them. It makes sense of it. It does mean that what the WMS is doing is providing a broad facility in terms of standards that go above building regulations. One stands back, what one finds within the WMS is a framework that's consistent with Section 1. So just going then to the question in this case of frustration, purpose, etc., it doesn't go anywhere once one understands that. There is a question I think we've adverted to, or I've adverted to in the course of this morning, about whether Section 1(c), given what's said in Section 1(2) of the Planning and Energy Act, is effective to occupy the entire space as far as energy efficiency policies are concerned, and the general rule would be that whether specific provisions on an area that would displace general provisions. That's not something I've given, I can entirely confess, considered thought to, and I don't think to respond to this claim I need to. I think there's two possibilities. One is that it does. The other is that it doesn't, but in terms of what residual discretion is left, that's limited.
I think this is maybe my fault because I raised this, and I'm wondering whether it is right to look at it in that way. Another way of looking at this is to just say that Section 1 was introduced to be read alongside the general powers to make policy, or in fact a duty on the part of local planning authorities to put their land use policies into a development plan document. And I wonder whether the genesis of Section 1 in the Private Members Bill is that there might perhaps have been debates going on at local planning inquiries, even planning appeals, about whether it was appropriate to have in a planning policy something which was dealing with building regs. You can imagine that sort of forensic argument being deployed at an inquiry. So maybe that explains why a Members Bill comes along to declare, to use your language, that you can. Because planning has always been a bit fuzzy about overlap between land use planning issues and, shall we say, environmental issues. And they're not seen as being in watertight compartments. And it's dealt with partly by policy. It's dealt with, is it the Gateshead decision, Lord Justice Glidewell? But you can see how in practical terms local authorities might still have been encountering difficulties when they were trying to have these policies accepted through an examination process. So along comes Section 1, which is declaratory, but just looking in broad terms, any policy or any central policy about the contents of local policy has to admit of exceptions. And indeed, that was where West Berkshire ended up eventually. Government was entitled to have its WMS, but it didn't preclude local authorities doing different things on affordable housing locally. So maybe the person who drafted, or the team that drafted this WMS, had regard to an additional legal principle that policy has to allow for exceptions, and they sought with the criteria to express what they thought might be acceptable exceptions.
I think for the WMS,
reading it that way, Section 1 does not exhaust the territory. It's just to be read alongside.
And I don't think it's a matter that the court necessarily needs to determine, but I think if it doesn't exhaust the territory, it nonetheless represents a statutory framework for the exercise of the power, and it's the point that's raised against me on ground 2. And being a statutory framework for the exercise of the power, one would expect at the very least that it would be generally adhered to. So there would be residual discretion, but it sits there as a statement and a power that's available to local authorities. And I did think on this topic, the question arose yesterday in Mr. Goodman's submissions about subsection 4 of section 1, which is the saving provision or the statement that the power has effect subject to, among other things, section 19, section 60 and section 62. And that might be, if one was to get into it, that might be relevant to whether or not it was intended to exhaust the space. And maybe said, well, actually, that's an indication that it's not intended to exhaust the space, because it allows for scope for those planning policies coming through development plans, and all those provisions are basically about policies. However,
I think it is. You say it's not relevant and we don't need to deal with it, but it seems to me that it's absolutely critical to the outcome of this appeal, because if what you had shortly submitted is correct, that the WS is in fact the thing that allows you to go above the building standards regulations, either with the draft or with the things that it says meet the 2 bullet points, then there cannot be an argument that the written ministerial system is restricting the power under section 1. It is the vehicle by which section 1 allows those things. If, however, there is another power which is being used, which appears to be contemplated by the written ministerial statement, then Mr. Goodman does have his arguments that that other power is being restricted by that. So I don't think the department, the Secretary of State can say, oh, it doesn't really matter what I'm doing. I think the Secretary of State doesn't need to know which powers they're acting under and which powers they're seeking to constrain. Is this an expression of national guidance for purposes of section 1 and 2, or is it the recognition of some other power which exists elsewhere, which they are, in inverted commas, seeking to constrain? It does seem to me to be, I thought that's what the case was about yesterday.
Well, the argument, just following up on that, the argument here has come about because of a very specific power in section 1. No one has suggested, I'm not aware of any other alternative specific power. If we're talking about a general power to make policy in the 2024 Act, then of course central government policy about the approach to plan making does in some respects constrain what local authorities should or should not do. It feeds through to the soundness test. But that is, if you're dealing with a general power to make policy, is not being frustrated by the application of central government guidance. I mean, if it were to be, then we could tear up most of the MPPF.
That I think, in the High Court, there was reference by the claimant then to section 19 and section 38.6 of the planning section. The judge rejects that.
38.6 is just dealing with decision making on planning applications, but section 19 is dealing with policy. We've got that in the bundle, haven't we?
Yeah,
we've got that. I mean, that argument's not pursued on appeal, and in my submission, rightly so. Okay, well, I barely spotted it, but in any event, it's a bad point because the policy making is clearly, as my Lord Justice Holgate has indicated, subject to national guidance.
Well, the House of Lords in Auchenbury recognises the role of the Secretary of State as the central planning authority to bring what the House of Lords calls coherence to the planning system.
So I don't mean to shirk the point, but the highest that the case could be put against me is section 1(c), and the strongest version of that is, well, that's what you look at, and that is the only place that you look at. And in my submission, even on that analysis, if it does exhaust the statutory possibilities or the powers of local authorities, the written ministerial statement is entirely consistent with it, and that's where I've got to, looking with a little bit more care over lunch at local energy efficiency standards as expressed on page 304 against section 1 of the PEA 2008.
Is the relevant subsection in section 19(1) capital A?
Well, not only, because the provision, subsection 4 refers to the provision as a whole. I wonder if it's really 1A.
Did you say 4?
It's subsection 1, so subsection 4 on page 27. across from page 27, this is section 1, it says that the power in subsection 1 of the Planning Energy Act is subject to...
Yes, that's the cross-reference.
Yeah.
So if we look to see what is relevant in section 19, I think reference has been made to 1 capital A. But then just reading that, development plan documents, taking up, must include policies designed to secure the development and use of land in the area. So,
but in any efficiency standard, would it be a development policy on the use of land? In that case, you wonder why section 11C is there at all.
It provides what it provides. It does it within a national framework. It's a private members bill.
what's unusual about it is it specifically refers to building regulations and exceeding building regulations, suggesting that that was the potential problem.
I'm not going to argue that it is the best articulation of policy through law or law that applies to policy. But I certainly do argue that the Written Ministerial Statement is entirely compatible with it. And whether it represents a strong statement of what should be done in terms of energy efficiency policies, or whether that leaving a residual discretion, whether it exhausts the space in that is an issue the court may want to enter into, but in my submission it doesn't need to dispose of its appeal. I'm tempted to say that's all I have to say on ground 2, except I want to make some very minor comments, which I'll make quite briefly. I give in my skeleton argument references to Hansard. The judge relied upon Hansard. The position in my detailed grounds was that there's no need for the court to have regard to Hansard, but if it wants to, it might. And the reference to that is para 29, Court Bundle 241. At the hearing below, it was common ground between the parties that there was ambiguity. A discussion was had about section 1, and as the court maybe can understand, given the discussion we've had, Mr. Justice Lieven, I think entirely justifiably thought, well, let's look at Hansard and see whether that helps. In my submission, when one looks at Hansard, it does help, and it helps to confirm the construction, i.e. this should be done within a national framework that the Secretary of State promotes. I think one doesn't need to go to Hansard for it, because actually one can get to that same point by just looking at the statute provisions themselves. So this isn't a case of ambiguity that needs to be resolved by reference to Hansard, but I entirely understand why we looked at it below, and indeed I think it was helpful to do so.
But which is the relevant part of Hansard? Is it just the bit that's quoted by the judge?
I can give the court the references. I think I include them in my skeleton argument, so let's see if I can do it that way. So para 87 of my skeleton argument, I quote from the previous debate. Now this wasn't a bit that was referenced by the judge. This is Caroline Flint, who was the minister.
I mean, is she making a statement about what the clause means? You know, we've got to have some discipline.
I wanted to address that point briefly as well,
right.
so I'm grateful that you've raised it. Again, there was common ground that these passages were relevant below, and it's right, it's a private members bill, so it was promoted in the first instance by Mr. Fallon, but it entered into a period of discussion. It was not supported by the government to start with. It was then supported by the government subject to a complete substitution. And in the debates, one finds Sadiq Khan, and then before him Caroline Flint, speaking to those provisions, not as a matter of debate, not in the capacity of private members, but
saying
as
this
government
section
ministers.
means that thing.
As government ministers, and that's the place where one finds that. So, and I don't think that Pepper and Hart is singular in that sense. I think it's possible for, within a debate, one to identify a promoter of the bill and an authoritative government spokesperson on a bill. I had a quick look at this, and there has been some discussion about in coalition government times, whether one could have multiple people making authoritative statements. But my simple submission is, insofar as the judge looked at Hansard and was right to do so, it was appropriate that she treated these ministers' statements as authoritative, given the capacity in which they were made, and no issue was taken against that. I think that was right.
And you say that what is said there is consistent with your construction of the Act?
Yes.
In which case, what did the Act achieve? By the time the government had amended it.
Well, the Act achieved an ability for local planning authorities to exceed building regulations for energy efficiency requirements.
Would they not have had that before?
It's declaratory in that sense.
So it's just making clear what they could do.
But insofar as it's making that power clear, it imposes on it the need to do it within a national framework.
Yeah.
Well, even that isn't right from what you've just said. Can I be absolutely clear? If a local authority decided to adopt standards for energy efficiency which were not in the FHS and not in the building regulations, but which satisfy the 2 bullet points in the WMS, they can do it, whether you put them in your own other guidance or not. So you're either recognising the WMS allows local authorities freedom, or, although you say we don't need to decide, you're recognising that Section 1 isn't the only show in town, and it's probably Section 19(1)A or possibly something else. But at the end of the day, the freedom that CRA says local authorities have to adopt things that are not national standards, but are purely local standards, exists, so long as you can satisfy the 2 bullet points.
The WMS is a statement of policy. That's absolutely right. Insofar as whether Section 1(1)C constrains them, we've had that debate. And if it's right, it's declaratory, doesn't rule out other action in this space. The written ministerial statement is expressed in strong language, but there would be nothing to stop a local planning authority acting even beyond the 2 criteria. They could do it. It just wouldn't be consistent with national policy. That's perhaps the question that I'm trying to make sure is accommodated in the debate before us, but not resolved, because it gives rise to some more difficult issues.
One of the passages referenced in your skeleton, presumably, is the Sadiq Khan passage.
That's quoted in the judgment, so I don't quote it again.
Well, yes, I'm just looking at that. The judge thought that was obviously the best one to use. And I'm just looking at it again at paragraph 65. Intention was for local authorities to choose only those standards that have been set out or referred to in regulations, or which are set out or endorsed in national policies or guidance.
Which is supportive of displacing powers rather than leaving some residual discretion.
But I have written down, but I fully understood me, and I will write down at some stage, that is not the only thing that can happen. Because as I understand you, you accept that a local authority can impose quite different and higher standards, so long as you can justify them by those bullet points, even if they're not in any national standards at all. Either because the WMS is the standard authority, or because there's a power somewhere else. But they have a freedom that goes greater than that which is summarised in paragraph 65 of the judgment.
My suspicion is that WMS opens up that option consistently with Section 1.
Because
1C.
it is the thing that allows the fixing of the standards.
That's my suspicion on that.
I mean, which would also be consistent with this statement, but then it just raises the question, how useful are these Hansard extracts? Because you can get to that position from your analysis of the statute.
As I say, I think I don't submit that we need to go to Hansard to resolve this debate. I think one can find a reiteration of much the same things in Hansard, so it confirms what I'm saying, but it doesn't resolve it.
You said you had a couple of other points.
Yes, I probably should, although I'll take it very quickly, address my learned friend's argument about energy efficiency standards meaning metrics. I respond to that in my skeleton argument, and it's at paragraph 91 of my skeleton argument that I set out what that would do. So it's bundle page 49 and over page on 50. Effectively, what my learned friend said yesterday is that standards means metrics, and that smacks in my submission of Humpty Dumpty. Standards may be related to and incorporate an idea of metrics, but clearly standards is a broader term than metrics. There's also a point that was canvassed in discussion yesterday that I would align myself with, that if this was the case, it wouldn't help the appellant's arguments, because within the ambit of section 11C, it would have two consequences. It would mean, firstly, that only as regard metrics, that policy on energy efficiency exceeding building regulations could be made, not as regards any kind of level.
Not with regard to...
Not as regards any kind of level.
Yeah.
So it's probably useful to distinguish metrics and levels. And secondly, because the LETI metric or methodology is voluntary, is not endorsed in any way by national authorities, it would mean within the ambit of section 11C, because of section 12, that LETI couldn't be promoted, not using that power. So it would in effect, be very limiting, and I think it's probably fair to say it would be an entirely different legislative outcome. And there is a reference in the authority bundle to a passage in Benyon 12.1. The reference is in the bundle, authorities bundle, page 959, making the fairly well hackneyed point that you cannot use a purposive interpretation to achieve a different legislative scheme.
So local authorities would be better off with your interpretation.
It backfires the appellant's interpretation.
Coupled of the statute, coupled with this WMS.
Unless there was anything else, that was what I had on grounds too. I'll just put it down.
Thank you.
Thank you.
Thank you very much indeed. That's a good one.
Yeah, my lords, I reply first on ground one. Can I take the court to tab 14 of the core bundle, page 163? It's the grounds of appeal, and to remind the court of the first ground, the judge erred in her interpretation of section 19 of the Environment Act 2021, and Roman 1, the judge failed to understand that the duty to have due regard under section 19 is not discharged by way of a rearguard assessment. On that point, I submit the appeal should be allowed, and her judgment, paragraph 44, should be set aside. My lords would turn to paragraph 44 again at tab 9, page 139. Where she says that in terms of Mr. Goodman's specific complaints about the defendant's compliance with section 19, the first point is the acknowledged failure of the Minister to have regard to an assessment of the EPPS at the time she made the WMS. However, the case law, even on section 149, is clear that such failures can, in appropriate cases, be remedied later. This may be described as a rearguard action, but it's apparent from cases such as Rowley that a later assessment can meet the statutory duty. So her finding is that the duty was met by the later assessment.
It's a bit ambiguous, isn't it? Is she really saying the events of December 2023 can be treated as if they've never happened because the duty can be met? Or is she saying, going forward, it's fine, because when she says at the end, it's not appropriate to make a declaration of unlawfulness, she seems to accept that there was unlawfulness. It's whether she should grant a remedy for it that she's talking about.
It's the former, my lord, and that's very clear when one has regard to the way in which it was argued, the way in which it's argued before this court for the Secretary of State and to the judgment itself. So we can see, first of all, at paragraph 45, where she says that is reinforced by the fact that section 19, read with section 47, expressly defines the making of the policy as including the reviewing of the policy. So she is referring to the duty there, the making. When making policy, there must be due regard, as including reviewing. So her understanding of the duty, because it included the later stage of reviewing, could be saved by the later act of reviewing. That's not a point that's been pressed in oral argument at this level, but that was the argument before her. And we can see that in the way in which the argument is put in this court. So if my lords turn up the skeleton argument of the Secretary of State, it was again put in that same way as it was before the judge below, that we saw at paragraph 6 and then principally at paragraphs 53 and 54 of the skeleton argument. There is again an acceptance at 53 of what's characterised as, to that limited extent, the minister who approved the policy as finally adopted did not have due regard to the EPPS in breach of section 19.1. However, that should not be taken to imply that due regard was not given to the EPPS in developing and maintaining the WMS, nor does it mean that the admitted unlawfulness is of great consequence in the particular circumstances of this case. Import should be afforded to the due regard given to the EPPS when the text of the WMS was approved in October, the due regard given in the design of the FHS, and the analysis carried out in 2024. And so the argument is still, or was still maintained, that there was no breach of duty. Now that may have been dropped in the course of submissions before the court, but it was certainly the way in which it was put before the judge below, and that's the premise on which the judge below decided the matter. So that does then emphasise why it's important that this court clears that up, because the judge below thought there could be no breach in the circumstances of this case because of a later assessment post-adoption. The Secretary of State made that argument and maintains that in the skeleton argument and at least up until oral submissions today. So that is the Secretary of State's understanding as well as the judge below's understanding. And that emphasises the importance of this court allowing the appeal on that ground, under ground 1.1, so as to make clear that the judge got that wrong in paragraph 44.
But the appeal is against the order, and the order was that the claim is dismissed. You've still got the problem, and you put the respondent's notice that if in fact there was a breach, as you might have thought some of us seem to think there was, the breach was not of such significance that a remedy was called for.
Yes, and we come to those submissions next, but it's important that on that point as to breach, that the court recognises that that is if the court goes down accepting that submission, as my inference from the judicial comments is that it may do, that is made very clear that that's a distinction between the way in which this court is deciding it and the way the court below is deciding it. Can I give the references to the pleadings below, which just put that beyond question? The statement of facts and grounds makes that clear. I don't need to take the lordships to it, but it's tab 16, page 186. And in particular, paragraphs 33 to 34, and then the skeleton argument of the claimant below, paragraph 21, which is page 264 of the core bundle.
Sorry, 21.
Paragraph 21 of the skeleton argument below, page 264.
Well, you also have paragraph 39 of the judgment, which summarises it quite clearly.
Sorry, I didn't hear.
You have paragraph 39 of the judgment, which summarises the position.
Yes, thank you, Lord. Now, coming then to the second consideration, so the February-March consideration, I just wanted to come back to my Lord Justice Lewis's inquiry of me yesterday and of my learned friend this morning to understand what is actually required where one has a breach on that premise and the Minister is revisiting the situation now. So again, on the premise, not the judge understood it, that one could avoid the breach, but one is trying to do one's duty in an after the fact of the breach scenario. So I don't design a template for every scenario, but to answer...
It wasn't, sorry to interrupt, but it wasn't just entirely after the event, because the Minister was still deciding the policy going forward.
So that's the premise I'm trying to answer. Is that was what my Lord Justice Lewis was positing, was we've moved on from December. We know that there was a breach in December, but the Secretary of State still wants to look at the duty, recognising that there has been a failure. How do they go about that duty in the circumstances they find themselves
look
in?
at a duty, but also decide whether to maintain the policy.
Well, that's what we say needs to be done, is to make a fresh decision about whether to maintain the policy. And when that's done, the Secretary of State at that point has to have due regard to the EPPS. And the context of where that applies there is that the breach has occurred. And so you have a policy that's been made in breach of the duty. And so the Minister has to ask herself this: we failed to comply with the duty. So what I want now to see whether we should go forward with this policy is to ask myself, did we manage to integrate the environmental principles into the shaping of that policy? Because that's the core component of the EPPS duty.
That you've just referred to the integration objective.
That is one of the objectives as well.
Yeah.
But it's all of that policy I took the court to. The shaping is one of the words used. Formation, formulation, all of those words.
That's the integration principle.
Integration is one of the 5 principles, as well as the general obligation to shape, to make, to formulate the policy around the principles as a whole. That's what.
Yes, but not all the principles are engaged here.
No.
The precautionary principle, for example.
Yes. So here we have the integration and prevention principle. So did we shape it around the integration and prevention principle? That's what the Minister needs to ask herself.
Well, she's not. She's saying, did we take a decision that did that? She's asking herself a simple question. I've got to decide whether to maintain this policy, having due regard to the Environmental Protection Statement.
Yes.
She's not conducting an historic inquiry into whether or not it was shaped. She's deciding now, given that the duty applies from the 1st of November onwards, should I carry on with this because I'm satisfied, having due regard, that this policy is right?
Yes. What I was trying to assist with was, my Lord was asking, in practical terms, applying that duty, what does it actually mean?
Yeah.
So that's what I'm trying to give a practical illustration of for what we say the Minister had to do at that point. So I'm going beyond what my Lord's posit of, here we are, I'm applying the duty, EPPS. What does that actually involve? Well, the EPPS itself says that the principles within the EPPS must be woven into the fabric of the policy, into the warp and weft of the policy. That's what the EPPS requires of ministerial policy making.
Yeah.
And so when the Minister asks herself, have I complied with the duty, she needs to ask herself, did we achieve that? Did we weave the environmental principles into this policy making? Now that doesn't mean she has to go back to step 1, but she needs to ask that question. Now that involves asking, in essence, is there anything better in terms of the environmental principles that might have been achieved? Were there options we looked at? Were there alternatives?
So you said, were there anything better than the environmental principles?
Anything better from the perspective of the environmental principles? So was there something that better integrated? Was there something that better prevented harm?
Better than the WMS?
Yes. Now the answer may be no, but that would be a consequence of having applied the principles. But that's what the Minister needs to ask herself in order to have due regard to the substance of the EPPS, because ultimately the objective is to improve the environment. That's what we're looking at. And the mechanism for doing that is to weave these principles into the formulation of policy. And so she needs to see whether that's been done or not. That's the question she needs to ask.
And what effect does the October non-statutory reference to EPPS have in that regard?
So I was talking there at a level of principle. So then the briefing that she needs to demand or needs to be given would explain the answer to that question. And in that briefing, it would say, well, we did look at options and alternatives, and here are the options and alternatives that we've looked at. And we are satisfied either this is the best policy, or it's not actually the best policy, but it's outweighed by other things. But this is how we wove these principles into the policy making, and then she can make her decision. Obviously, all of those elements on the merits are obviously for her, but that's the process requirement. And so the October decision would be a component of answering that question, whether the application of the principles has been woven into the formulation of policy.
But the minister who took the decision in February knew all about the October one, because he's the one that had it in October.
Well, I've explained I'm talking about the level of principle. My Lord was asking yesterday,
Yeah,
what is the approach that the...
And you seem to say there's two things. She's got to look backwards to see whether during the process of development this was integrated, and she's also got to say, looking at it today, is there anything better that could be done, more compliant with the environmental principles than what's in the WMS? It seems to be that you're doing both. But in answer to my Lord's question, she's got to be told about the October assessment. It was a he by then. It was the man who'd been told about the October assessment, as I understood it. He'd been told that in October when he approved it first time round.
Yeah, well, we're getting back into the facts. I was trying to stick to the question of principle.
Level of principle, okay.
Yeah,
Yep.
but that's what I say is the principled approach. And so when my Lords look at what happened then in February, I don't want to go back over all of that again because this is a reply, but that's what I say is the measure of whether the duty was complied with in February is I put it this way, that it includes that crucial component that was the EPPS woven into the formulation of the policy. Did she ask that crucial question? That's the focus the court should be having when looking at whether the duty was discharged subsequently. And if the briefing in front of her doesn't enable her to ask that question, then she needs to ask it. She needs to go back and say, what happened? What alternatives? What options are there? Is there anything I'm missing here? Were there any opportunities that we missed that would achieve the environmental principles? What did we look at? What was the analysis?
So is that ground one?
That's ground one. Yes.
Thank you.
On ground two, let's take the court back to my skeleton argument before this court. Paragraph 37. This is the point about section 1.4a that we were, the court was just considering with my learned friend, where it's set out section 1.4a provides that the powers conferred in subsection 1 of the 2008 Act is subject to section 19, and then we set out 1 and 1a and 2 of section 19. Then at 39, we said that section 1 put beyond doubt certain powers which had already been held and exercised by local planning authorities, and at 40 we say it put beyond doubt that local authorities have specific as well as a general power to include energy policies in their development plan documents, and then we referred specifically to the general powers of section 1 of the Localism Act, sections 15 to 19 of the Planning and Policy Purchase Act, and section 111 of the Local Government Act. Principal among those, or the most specific obviously, is section 19 of those sets of powers. Section 1 and section 111 are very general powers, as the court will know.
So the WMS is not a 11C document, as Mr. Westray was submitting. it's actually a development policy under section 19(1)A that's preserved power by section 1(4).
No, so section 19 is about the local development policy. So the WMS is a national policy.
Sorry,
so
yes, but you could do standards, or you could have a policy which includes higher energy standards, but that would be a section 19(1)A policy preserved by section 1(4). You don't have power to adopt policies of your own volition under section 1(1)C.
Well, we say both.
Well, you say both. You still say.
Still say both. Yes, I know that I know that your position has moved on, but
No, I'm just trying to find out what the law means.
No, we still submit both. So if section 1 of the 2008 Act didn't exist, under section 19, local authorities could set policies in their development plans which set energy efficiency requirements beyond the building regulations. Yes.
Right, so it's definitely, you say section 19(1)A, but you continue to maintain that the fixing of higher energy standards by a local authority would be permissible as an exercise of power conferred by section 1(1)C.
Yes. So the proper interpretation of what Parliament was trying to do with section 1 was to give specificity to that general power, subject, as in 1 subsection 4, to not cutting across it, but to further enable with greater specificity that power that already subsisted.
If the power is to make such policies at a local level, it's not necessarily section 1 of the 2008 Act. We point to section 19, subsection 1A. The general power to make policies in the local plan, section 17.
Yes.
Both of those powers are very general.
Yes.
The more general the power, the more difficult it is for you to mount your ground 2 argument that a WMS, such as we have here, undermines the statute. It is the function of WMS and the NPPF to give guidance on how these general powers be exercised.
If we forget that section 1 ever existed, then you would have a situation where the WMS would operate as a guide, so long as it doesn't cut down the policy impermissibly, and would act as a material consideration.
So that's where I was overturned in West Berkshire. And that's binding on this court.
The Court of Appeals,
Yeah. So your argument under ground 2 is actually dependent upon reliance on section 1 of the 2008 Act.
Well,
it's that which makes the difference.
Well, it's the two, as my lord put it, side by side, is the way we put it.
But without it, ground 2 doesn't get, sorry to put it this way, off the ground.
Well, I don't make the argument without it, so perhaps we don't need to hypothesize.
Yeah, but it's useful to understand
Yeah.
when we're being asked to look at these other wider powers as well, how they fit into the picture.
So it is critical for your case then, so I've understood it, that section 1(1)C does confer a power on a local authority to adopt standards in excess of the building regulation. Because it's because it does that, the WMS is an improper veto on it.
Yes. So to put it in sequence, we say that they had that power, and then section 1(1)C, as indeed 1(1)A and 1(1)B, give specificity so as to put that beyond doubt. But they also have that power in partnership under section 19.
But what happens if we decide that you're wrong about the interpretation of section 1(1)C, but we don't accept Mr. Westway's argument that local authorities can't do things off their own bat, and we think section 19(1)A gives you the power, then the WMS doesn't conflict with section 19(1)A, does it? Or does it, on your case?
Well, our primary case is it does, but if we take my Lord Justice Holgate's indication of where the court thinks that takes matters, then the consequence would simply be that the WMS stands as a material consideration that has to be taken into account both in plan making and in decision making. Like any WMS, that's.
And would that be unlawful if you haven't got the power under 1(1)C and you're relying on?
Well, we say it purports to go beyond what is lawfully permissible for the WMS by purporting strain local authorities from the exercise of powers that they have, both within...
Yes, which powers I want to know. Is it necessarily 11C, but if you lose on 11C and you get a judgment, and we haven't decided it yet, which says you ain't got the power under 11C, would you still win or could you not win on section 19(1)A?
Can I just go... I just need to put the WMS in front of me to
Yep, that's
put
fine.
that in front of
That's
my...
probably a good idea, actually, to take it out and putting it back myself. One needs to have the thing in front of you, yep.
So in that circumstance, paragraph 3 of the WMS, which purports to set this out as an explication of the legislation in 2008, would be inaccurate.
What, the paragraph beginning in 2015?
Yes.
Yeah.
So what it's trying to do would be an incorrect statement of the law, infringing the principle in the A case in the Supreme Court, because what it's trying to do, it says, is to explain the 2008 powers, not the section 19(1)A powers, section 19(1) powers.
Sorry, what would actually be wrong about the third paragraph? What precisely? Passing over that question, if I followed correctly, we're looking now at...
Well, yeah, I mean...
I'm sorry, after you.
Yeah, sorry, just to answer that. I mean, that third paragraph is a contextual paragraph which seeks to explain why the WMS is being made. But if, in fact, the WMS is only relevant to section 19, the ordinary general policy-making powers, then that's misplaced. It's evident that the background to why this policy statement is being made...
Well, it would be OTOs, but it wouldn't render the WMS unlawful.
It would be OTOs, but would indicate that the intention of the WMS is to address section 1 of the 2008 Act, and that that's misplaced. So the starting point would be that it's mistaken in what it's attempting to do.
Well, it may be.
Yeah. My Lord asks.
But so what?
Well, that's
the
the
question
first
is,
point.
where's the illegality?
Yeah. So that's...
It doesn't require you to do anything unlawful, or it sets out things that are factually correct, but you say are not germane if we're into 19(1)A.
I thought you were going to come to the fourth
I am,
paragraph.
Lord. Yeah.
Oh,
I'm
yeah.
just
That's
trying
the
to
key
start.
paragraph.
Because I don't think really we need to spend time on the third paragraph.
So the fourth paragraph so So, just so I'm answering the correct question here, the question is, are we assuming section 1 doesn't exist?
No, we're assuming you're wrong in your interpretation of it, and it does not confer a power to adopt energy efficiency standards in excess of the building regulations. Nonetheless, section 1.4 preserves 19 of that other act,
Yes.
and subsection 1A is broad enough to include within the relevant plans, whatever they're called, a power to fix energy standards in excess of the building regulations. And the question then is, if you exercise power under section 19.1A to make plans, does this document, page 304,
Yes.
in some way unlawfully restrict the power that you have under section 19A, 1A?
Yes.
That, I think, is the question.
Yes. So on all those premises, which are obviously alternative to our argument, the answer is still yes.
Yes, because
the policy still seeks to impermissibly restrict what is available to local authorities under their powers. So, for example, to restrict to the use of the target emissions rate in the second bullet point, because it's attempting to prevent local plans from using standards other than that, and is attempting to prevent local plans from using standards that go further than the FHS.
But why is that legally impermissible?
Because that cuts across or cuts down the powers which are set out in section 1.1c.
But that's what happens when central government makes policy of this nature. And the other question is, how is your submission compatible with West Berkshire?
Well, we've set out in the skeleton argument the authorities on where the line is drawn between what's permissible and what's impermissible. There are limits to what you can do by policy, and we say it crosses that line. That's because you have a statutory power that's express and specific to set standards that go beyond FHS, and this purports to limit what those standards can be and limit the extent to which they can go beyond FHS. So if
you're right, that has major implications for the Secretary of State to make policy in the future outside this area affecting local plans.
Well, only to the extent of the existing authorities which I rely on. So don't ask the court to go beyond the established principles on the limits of the policy-making powers.
And that's really your ground two, is it?
Yes, my lord. That's all I need to say.
Thank you. Is there anything further that you wanted to raise? No?
No.
Well, thank you. Thank you all very much indeed for the excellent submissions that we've had. It won't necessarily surprise you to know that we won't be giving a judgment this afternoon. So that will be reserved. It will be distributed in the usual way with the provisos on redistribution. So please observe those, because it's very disappointing to get into issues of contempt. And as ever, we will try and deal with it as soon as we can. Thank you all very much indeed for the assistance.